A very warm welcome to another edition of Europe Calling, the webinar series which brings together European decision makers, European experts and citizens. And this time in a special edition as a lunchtime seminar. Unfortunately, this time no coffee, no sandwiches served. You have to do this yourself. But I'm very proud to join forces again with my dear colleague Franziska Brandner from the German Bundestag, European spokesperson of the Greens in the Bundestag, and of course, our common treasure, I would say, our legal scholar from Rotterdam, Professor René Repasi, expert on European and German constitutional law. And the main reason for this webinar is clear. Again, people were highly nervous in Brussels, I can tell you, before the recent clearing of the Constitutional Court for the signature of the German president for the recovery program in the framework of the next European budget. Okay, this time Karlsruhe gave green light, at least for the time being. But what next? What next from Karlsruhe? There are already a lot of Karlsruhe jokes in Brussels. And the best joke is that our expert here, I first met in Karlsruhe because actually he comes from there. At least he spent a great deal of time there. And therefore, he's not only a legal scholar and therefore an expert, but also he understands the deeper spirits of Karlsruhe. And that is why this seminar is so interesting. So René told me some time ago, he prepared a talk for his students on the matter. And I thought, what's good enough for his students has to be, in any case, here on our stage. And therefore, we are looking forward to your input to tell us what are the next threats which we may be expecting from Karlsruhe. How can Europe prepare for this? What about the future policies of the ECB? Is there still danger for the PSPP program, for the PEP program? And in particular also for future possible programs of common investment, because we as Greens support, of course, like all pro-Europeans in Germany, that Europe changes course and finances common investment based on common taxation and uses short-term credit in order to pre-finance the income it generates later. So therefore, we want to, of course, Europe to succeed, but of course, we want to respect at the same time the constitutional framework in Europe as well as in Germany. And therefore, it is so important what the Constitutional Court in Germany said. Secondly, there is a long-term quarrel between the high courts on the national level and the German High Court in Karlsruhe in particular, and the Luxembourg-based ECB. And therefore, many people in the European institutions wonder what is really behind this conflict. Will it proliferate? Will it go on forever? Or perhaps some new judges will change course? God knows. So we are now interested to learn from René what he thinks is coming, and then in the end, Franziska Brandner will draw the conclusions, because obviously what you are sharing with us is of high value for European policy making, but equally for what we will do in the Bundestag in the next years. So, René, the floor is yours. And lastly, before this meeting is recorded, we welcome your written questions. Please read the questions in parallel if you like. And the best questions, you can give a thumbs up. And by that way, we can ask the most pertinent questions to René at the end of his talk. And lastly, if anything important is being said, please share it on social media. And by that way, also make more people listening to this event, which will then afterwards be available as a video. René, the floor is yours.
Yeah, dear Sven, dear Franziska, thanks a lot for having invited me to this session at this short notice and at this indeed uncommon timing for the event. But I think it's the right framework to discuss the matter. The issue that I want to talk about is, it was already announced in the for the webinar. It is about Karlsruhe. So the German Constitutional Court, what's next from it? I would even say pronunciation linked to it, especially when you look outside of Germany. So I will have a first emphasis on what is currently mainly discussed. So the court's interim relief decision on next generation EU and what is to be expected from the main proceedings. But we'll also have a short look at PSPP and the PEPP proceedings, plus giving the outlook at what is actually behind all this and what can still be expected in this particular relationship. And indeed, Sven introduced it, I'm born in Karlsruhe, raised in Karlsruhe. I lived there the first 19 years of my life, and I'm still looking back happily towards it. The football club of Karlsruhe is still painful, but still followed, although I'm living in Rotterdam. And the most funny thing of this is being still proud of my origin. We always consider the people a little bit more to the east, in the area of Stuttgart, as being particularly weird because they are turning around every penny that comes across. And the word of the Schwäbische Hausfrau is also known in Brussels as well. Yet it is the Karlsruhe court that seems to be the embodiment of the Schwäbische Hausfrau, which me as a born Karlsruhe is extremely painful. And that shows there should be more people being born in Karlsruhe on this court in order to change attitude. Yet that's for a future green-led government to decide. Let's turn now to our presentation. I want to share the screen with you, which can hopefully be seen now. So what next from Karlsruhe? Let's have as a prologue a look at what actually happened between the Bundesverfassungsgericht and in particular Economic and Monetary Union. And I'm saying this that I have a rather broad understanding of EMU, so that also what we currently see with the next generation EU is something I would put into the broader scope of this field. Now, it all started in 2011 with the Greek rescue package and the EFSF, so the European Financial Stabilization Facility. Then later was the judgment, first as interim relief and later with the final judgment on the European Stability Mechanism in 12 and 14. Thereafter, with interim relief in 14 and final judgment in 16, the OMT judgment, which included the first preliminary reference by the German Constitutional Court to the European Court of Justice in the case that later became Gauweiler. My own policy to only call it OMT was unfortunately not successful, so that an important case now has the name of Gauweiler, which from my German perspective I find highly deplorable. Thereafter, in 2017, interim relief, and 20, that God's judgment in PSPP or PSPP1, as we would have to call it, which also included a preliminary reference to the Court of Justice, which then got the name of Weiss. Now, we are still pending the second round of PSPP, so where the Court of Justice, where the German Constitutional Court is asked whether the reactions by the German government and parliament, both chambers, were sufficient given this judgment or not. This is pending since 7 August 2020. These proceedings got quite famous also in the German public debate, given that a new judge, because Sven was also speaking about new judges, a new judge that entered the court in autumn gave a very, let's say, progressive reading of this judgment and its consequences to a news journal in June 2020. And there was now a decision that she may not be part of the Senate that is deciding PSPP2, as she had given a couple of opinions on how she considers to see this judgment in a news outlet. So this decision then led to some uproar, given that some other judges were also involved in newspaper interviews without being banned from the decision here. So this decision is going to be taken now not by the full 8 judges, and the most progressive one on this Senate that replaced the former president of the court is not allowed to take part in the decision making. The second one is now on PEPP, the pandemic program by the ECB, which is pending at the Court of Justice since 4th of March 2021. And then the one that already made some noise, the one on the Next Generation EU, in particular the own resources decision, which is pending since 22 March 2021. Before having a closer look at this particular proceedings, a short background to what is actually going on legally speaking. And what we look at here, legally speaking, is a Gordian knot. It is an indissoluble conflict between, on the one hand, EU laws claim to be supreme over all national law, the principle of supremacy or primacy, depending on which formulation one prefers, and national limitations of the EU treaties. The starting point of this is, and there we still have common ground between EU and the German Constitutional Court, the EU is no federation. The EU legal order and the national legal orders are autonomous legal orders that coexist within the same territory. And when legal orders coexist within the same territory, conflicts arise. And these conflicts have to be managed. And that is done by a conflict rule. And this conflict rule is defined from the EU law side to claim primacy of all EU law over all national law, including national constitutional law. Yet such claim needs to be accepted or recognized by the other legal order on the territory, which is the national law. So national law is in that sense also free and autonomous in recognizing the claim of primacy of all EU law. That is done in Germany by the German Constitutional Article 23 of the Grundgesetz. And here the German legal order in principle recognizes this claim of primacy, yet it also provides for limits to this recognition. And these limits derive from the very fact that EU law is ultimately, in its essence, international law, based on a treaty concluded between states, giving rise to an international organization which we call the European Union. Therefore, the national ratification laws were the national ratification laws decided by parliaments that gave birth to EU law and approved its limits. As we know, the most famous expression of this is the principle of conferral, according to which the EU may only act if it explicitly has the competence to act in the treaties. It doesn't have, as we call it, competence, so to decide, well, I do want to adopt a certain measure, I do not find an explicit competence on that in my treaties, so I do it nevertheless because I want to do it. This is precisely what is not allowed to the EU, and that is accepted by all actors involved in this debate. Now, the German Constitutional Court defined what it thinks are the limitations to the claim of primacy of EU law, and that is protecting three important subject matters. The first one is the protection of fundamental rights that entered into legal history under the name of the Solange case law. The second one is the protection of the distribution of competences. That is known under the name of the ultra-virus case law, which means ultra-virus being beyond the limitations of competences. And the third one is the protection of constitutional identity. This one was added to the list in the Lisbon Treaty. And if you look into what the protection of constitutional identity ultimately means, it is the protection of national democracy. And the Court of Justice, the German Constitutional Court, by that saying, what remains with the Federal Republic of Germany must be open to the free determination within the political sphere. So any policy choices made in this sphere must also be effectively implemented. That means the protection of the remaining competences, but also de facto having the powers to autonomously decide on those matters. And since many policy choices entail budgetary consequences, the protection of budgetary autonomy is part of this protection of national democracy, which is at the core of constitutional identity. Now, this is the conflict. And given that we recognize the coexistence of two autonomous legal orders, whether when you're a European Union lawyer, you say it's the EU that decides on its limitations. When you're a national lawyer, you say it's a national legal order that decides on how much another legal order may intrude into the sphere of the national legal order. Legally, theoretically speaking, both are right, and it is hard to solve this. Therefore, there has to be a sort of fine-tuning in how we deal with this. Now, how did this now happen? Purely taken from the perspective of the German Constitutional Court in recent matters. Let me allow to be a bit more in detail when it comes to next generation, because this is currently discussed all over. It all started with a new German word introduced into the into the EU law speech, which is the beautiful German word of Hängebeschluss, which means to be hanging between decisions. And it can be best translated as an interim relief. It was adopted on 26 March of 21. That was quite a thing, since for the first time ever, the German Constitutional Court ordered the German president to not sign a law that was adopted by both chambers of parliament. And moreover, it was not even giving any reasons for that. So that created quite some uproar in the sense, what does this mean? Ultimately, it meant, give us some time. And give us some time to at least have still the margin of maneuver to decide in favor of the interim relief, meaning that the law approving the own resources decision is unconstitutional and must be rejected. Because ultimately we know if this law were signed and published in the official journal of the Federal Republic of Germany, then the German approval of the own resources decision would have been submitted, and the European Commission were to be empowered to start its borrowing operations, including all other consequences linked to this. So the court wanted to simply have the margin of maneuver to still decide. It didn't say anything in which favor it would decide. That then now happened 2 weeks ago, when the decision rejecting interim relief was published, and the decision was rendered on 15 April 2021. Yet, when we are looking at interim relief, the Constitutional Court in interim relief procedures does not decide on the substance of it, but it makes an assessment of the consequences of the successful interim relief as compared to not granting interim relief against the background of the accuracy of the legal arguments. And here the court concluded that the consequences would be more severe if the own resources decision wouldn't have entered into force than the other way around. So that was what the court in essence decided in this decision of 15 April. What it was looking at was first whether the payment obligations and the assumptions of liability under the own resources decision have the effect of essentially negating the budgetary autonomy of the German parliament. And by that, it's looking at the worst case situation. So in the very worst case, all member states are actually withdrawing from the EU, and all other member states refuse to pay on any kind of additional cost of the European Union. And the European Commission is not able to refinance any kind of liabilities from within the existing budget. What would then happen? Well, in this doomsday scenario, they are looking at liability for the entire 750 billion euro program under the own resources decision. That was then assessed under constitutional identity, because they wanted to see how much budgetary autonomy would there still be for the German parliament in case doomsday scenario comes. The second discussion is the empowerment of the European Commission to borrow funds ultra vires. And that goes into the discussion whether Article 311.3, speaking of own resources, so whether the notion of own resources is covering borrowing. And the third one is whether additional calls under the Article 9, so those additional calls, meaning there is a problem to meet repayment obligations from the European Union side, the Commission is not able to refinance them within the ordinary Union budget, then there's a possibility to call extra on the member states to pay for the repayment of the European Commission. And if a member state fails to meet these obligations, there can be an additional call for any other member state to provisionally provide for the necessary funds. And here the question is whether that is now violating Article 125, the famous no bailout clause, since some member states would just fail to meet their obligations, and then other member states would have to pay instead. So those were the three legal reasons that the Constitutional Court was looking at. Now, it decided against it. It considered the accuracy of the legal claims as being so unlikely that it turned towards the assessment what the consequences were if interim relief were to be granted. And it concluded that that was more severe than to approve interim relief, by that reject the own resources decision. So the consequences of this rejection of interim relief is that Germany is allowed to approve the own resources decision. As a consequence, the Commission is empowered by this decision to enter into borrowing operations for funds which are qualified as external assigned revenue to specific union programs. And that has as a consequence that the funds are outside of union budget and then also outside of the control of the budgetary legislator, so European Parliament and the Council. The allocation of those funds is done in accordance to a regulation based on our crisis competence, Article 122, also a regulation where the European Parliament is outside of the game. The use of the funds is later regulated by specific union programs, most prominently the Recovery and Resilience Facility, that itself is based on a legal basis where the European Parliament was then involved in the ordinary legislative procedure. We are then now entering the main proceedings of the German Constitutional Court. And that means, although interim relief was rejected, the main proceedings can still be successful. And at the end of the decision on the interim relief, you see an idea what the Constitutional Court wants to assess in those main proceedings. It wants to look at 3 points. The first one is whether the structure that was now established by the own resources decision together with Next Generation EU is the creation of a permanent instrument. So not something that goes beyond the COVID-19 situation, that essentially amounts to an assumption of liability for decisions of other member states. It then turns in detail looking at whether potential liabilities would structurally affect the budgetary powers of the German Parliament. And here, most interestingly, whether there is still sufficient parliamentary influence on decisions how the funds provided will be used. This is a little bit puzzling. In the German version, the decision was only speaking of parliamentary influence. In the English press statement, it was said that the Bundestag should have enough influence on how these decisions are actually made. Which means that probably it is about how much parliamentary influence the Bundestag has on those decisions, which is a rather obscure kind of statement, given that what is happening here is not additional funds by the European Commission giving to some outside fund like the ESM, but it is part of the European Union legal framework. So the European Commission is raising funds on behalf of the EU, which also makes it that it is the EU that has to decide on how those funds are later used. So the very meaning of this sentence appears to be rather unclear to me. We'll see what is actually meant by this in the main proceedings. Which also brings us that in the main proceedings, it is highly likely that the European Court of Justice will be involved when it comes to the ultra-virus elements of the proceedings. So I expect the preliminary question on first, whether Articles 4 and 5 of the own resources decision are in line with 311 and 310 of TFEU, meaning is the European Union actually allowed to enter into borrowing operations of that size? And the second one, whether the additional calls provision in Article 9 of the own resource decision is violating the no bailout provision. Here we are going then to get an answer of the Court of Justice of the European Union that will approximately take another 2 years. So we will probably have to wait around about 3 to 4 years until we precisely know what the German Constitutional Court means by this. The consequence of potentially successful main proceedings are the following. The German Constitutional Court can only address German institutions, and by that the German government, the Bundestag and the Bundesrat. The press statement in abstract speaks of limiting negative effects on the internal legal order as much as possible. The German version of the decision gives some examples what is meant by that. What is meant by that is that the German government should then reclaim any payments that were made under Article 9 of the ORD. Moreover, it should refuse any future calls on the German budget in this situation. Finally, it is encouraging the German government to veto any future MFF in case it finds the ORD to be unconstitutional until the own resource decision is adjusted to such a way that the German Constitutional Court would like to see it. I personally do not consider it very likely that the main proceedings will be successful. If you also look through the language of the German version of the decision, you see that the judges are rather reluctant when it comes to the accurate to how convincing the legal arguments by the claimants are. In that sense, I personally do not think that the main proceedings will be successful, so therefore be an impediment for next generation. What we will probably see is a judgment that makes clear that any permanent solution of that kind would probably violate the German constitution, yet nobody has intended to create such a permanent construction, and it is also not what you find in the own resource decision, that is something that is actually permanent. So that for next generation EU in all its limitations. There are more legal issues at stake, but that would go beyond the time limits that we also have here. Maybe later something is raised in the discussion. Let's have still a quick look at the German Constitutional Court and the ECB, what is currently pending. As I said in the introduction, there is PSPP2 running. Here the issue is one of formal nature, because the German Constitutional Court required in the PSPP judgment that a new decision by the ECB should be adopted, including a proportionality test. The ECB, however, didn't adopt a new decision. It was discussing proportionality in a governing council meeting of 4 or 5 June 2020, and it confirmed the PSPP decisions in the protocol without adopting new decisions. This was accepted by the German government, by the German parliament, by the German Bundestag as sufficient and meeting the requirements set up by the court. But is that the case? Now that is something that then in substance the German Constitutional Court will turn to. I personally do think that this is sufficient given the wording of the proportionality test in the judgment of the German Constitutional Court. Having said this, I must make clear at the very outset that I personally do not think that the German Constitutional Court was right in its own judgment. Proportionality is nothing that is to be applied in order to distinguish different categories of competences. Because that means, if you especially look at effects, they differ within member states. And that would mean that a monetary policy decision is one in Italy, but not one in Germany, because effects are different. So this is no benchmark that can be used for the separation of competences. Hence, I do not think that this test was correct at all. But if we acknowledge that this test can be applied, then the German Constitutional Court itself required an overall assessment and appraisal and did not have limited it to the economic effects of those issues it addressed explicitly in its own judgment. And since there was quite a lengthy proportionality discussion presented by the ECB, yet going beyond those issues that the German Constitutional Court raised, I still believe that that would be considered sufficient by the German Constitutional Court. It is a little bit more complicated when we look at PEPP, since also here the issue is not the one of competences. It is raised, but that is rather easy to be answered. Since in a situation that we had last year, it was very difficult to foresee whether the pandemic leads us into an inflation risk or not, by that requiring a monetary policy decision. So that this was monetary policy is rather easy to establish, but what is more difficult is whether there is a violation of the prohibition of monetary financing of states in Article 123 TFE. And that is due to the fact that both the European Court of Justice and the German Constitutional Court introduced limitations, certain criteria on limitations to check on whether a monetary policy decision is still in line with the monetary financing prohibition under Article 123. And these were waived in the PEPP decision. So one thing is, both courts said that the limitation to the capital key of the central banks in the ECB was core, in order to make clear that there is a separation of the maximum liability for national central banks. This is in general also the case for PEPP, yet it allows, in certain circumstances, to apply what they call a flexible approach to the distribution of purchase flows, which means that certain national central banks may have to purchase beyond their capital key. Although there is an obligation to bring it back to this capital key, there is a possibility to deviate from this. The second one is that there is no limitation of purchases of individual asset classes. So in concreto, when it comes to government bonds. So whilst there was a limitation in PSPP, there is none in PEPP. And finally, PEPP lifted the collateral requirements so that, for example, Greek government's bonds can also be purchased under PEPP. And that's also different to previous programs. So here we have, let's say, quite a deviation of this program when it comes to the prohibition of monetary financing. This will require absolutely an involvement of the Court of Justice, since they have to decide how do they apply their own criteria in that regard. It seems that the PEPP program is slightly deviating from those. And therefore, I expect a preliminary reference in the PEPP procedure that is precisely asking this. I do think that there is some leeway that the PEPP as it is made is actually in line with the EU treaties and also with Article 123 TFU, because the main purpose of this prohibition is to prevent any professional investors from having any kind of guarantee that the ECB is going to buy whatever they were purchasing. And by having this completely blurry design, it is, interestingly enough, increasing insecurities in contrast to having clear rules that makes it then also for certain investors rather predictable that at least parts of what they're holding in the portfolio could be bought by the ECB. So therefore, the European Court of Justice will have to discuss whether there's not some kind of trade-off and to which extent the very fact that we were in a crisis situation that even led so far that the Stability and Growth Pact was not to be applied anymore, whether this particular legal circumstances does not lead to a different set of criteria with regard to this particular problem. I believe there is a possibility to argue this. How convincing that will be for Karlsruhe, that is then on a second page, given that they insisted very much on those criteria. And as a consequence of the Gauweiler judgment, they were already stepping back from the hard criteria that they originally, with regard to the OMT program, were already introducing. If any proceedings are potentially successful, then we know this would mean the exit of the Bundesbank from purchases under PSPP or PEPP. So it is not the end of those programs, it's only that the Bundesbank would be out of it. Now, in order to wrap up, coming to the reasons for the critical stance of the court in the future. And this is something we all having maybe a very pro-European stance and pro-integration stance, we should nevertheless take into serious consideration. The reasons for the critical stance of the court is to protect national democracy and national separation of powers arrangements as the expression of the remaining national sovereignty. According for the court, it must remain possible that policy choices made in the political space of Germany can be implemented by majority decision in the national parliament. And that includes the budgetary autonomy of the parliament, and that includes that the political space in theory must be protected as well as that effects of policy decisions can take place. What the German Constitutional Court on this particular basis should probably still learn that this does not only apply in the European Union to the German space, but also, let's say, to the Greek space. So tying, therefore, Greece to certain kind of bureaucratic decisions that doesn't allow them anymore to have any policy space, while those criteria would also apply to other member states, making it maybe a little bit more delicate. Yet there is, in its essence, a point that is valid, because the more, especially in EMU, where the separation of powers at EU level is, let's call it precarious, where Parliament, not even the European Parliament, is properly included, it leads to a shift of power not only between the member state and the European Union, but from democratically elected parliamentarians to officials of institutions. And this is something that, as a critical stance, is not totally to be neglected. That brings me basically to the final point, how to address those issues. And here, as a preliminary remark, the first thing is not to ignore these reasons for critical stance or to downplay it. In its essence, it has something that is important. It is about democracy. And that makes it that one should maybe think to strengthen European democracy. If we go through all the critical German Constitutional Court judgments, they addressed institutions and constructs with the EFSF, with the ESM, with the ECB, but also with the Next Generation EU, in which the involvement of the European Parliament is quite low. European Parliament was out in the 122 decision, it is out in the ordinary resources decision. So there is no European democracy really present in those. It is true that the German Constitutional Court is mostly looking at national democracy, but the argument to which extent European democracy could serve as a substitute was never relevant for the decision, that was never tried out, to which extent that might not remedy some issues that the German Constitutional Court is raising. The second one is, we will not solve this problem, and that refers back to the background, by creating a super higher judicial super court, in which then highest constitutional judges come together with European judges and then decide who is right. Because that's not what it's about. In theory, both are right. And only if some super instance decides somebody else is right, doesn't make the other party to say we are not right. This is theoretically not possible. It is only a delegation of a conflict and not solving it. Therefore, the solution is rather to find in the already present judicial dialogue, but this judicial dialogue also has to be critical not only towards the European Court of Justice, but also amongst highest courts. And here we see an interesting development. Just recently, the French Conseil d'État made a decision that is can be seen as a response to the German Constitutional Court, giving the European Court of Justice the absolute power to decide on the legality of EU law decisions. And we also had a reaction of the Italian Corte Costituzionale that was also going in a different pathway. And seeing that it was very important for the German Constitutional Court in the past to base its reasoning on the fact that other highest courts are also having any kind of reviews of European Union law, the very fact that the French the Conseil d'État and the Italian Constitutional Court took a different stance will also trigger reactions in Karlsruhe, I'm quite sure. Now, initially it was asked, would there be any change if judges would change? Now, yeah, of course, institutions are living on the basis of judges, and more pro-integration judges will probably lead to a more European-friendly case law of the German Constitutional Court. Yet it doesn't take away that the very essence of its critical stance, or the protection of national democracy, is something that is ingrained in the case law of the Constitutional Court, and that not only vis-à-vis the EU, but also vis-à-vis other national laws, that sometimes the German Parliament had to be helped by the German Constitutional Court, at least in their perspective, to make stronger use of their own parliamentary rights. Now, that was a quick run through the German Constitutional Court judgments, in particular in the field of EU, giving a first idea what is happening on the own resources decision and next generation EU. A short addressing what is actually the reason for this critical stance and how a potential addressing of those issues could look like. Thanks a lot for the attention, and I'm looking forward to comments and questions in the remaining time.
Wow. So I think we didn't promise too much. This was really the most dense, concise explanation and introduction to the Karlsruhe spirit by someone from Karlsruhe I've ever seen. And I don't want to spend more time with making remarks myself, but the top ranked question in the meantime is, and we don't have more time than for this, and then it goes to Franziska. And the question comes from Klaus Feldmann. Why does it seem that only the German Constitutional Court sees issues? What about the Supreme Court of other member states? Are there no issues? So is this a Karlsruhe obsession? René.
Okay, so it's immediately, I don't know, maybe Franziska had also some points on
Franziska will conclude and has her.
Okay. Now, as mentioned before, Karlsruhe is not the only one, and we had already had in the past some other constitutional and highest courts that discussed the matter. The discussion what are the limits of the principle of primacy is a very old one in EU law. We had examples from Czech Republic, we had examples from Denmark. Even in the very past, the French courts raised these questions, so they are not new. It is clear, it is true that the intensity is the strongest coming from Karlsruhe, but it has also much to do with the very fact that Karlsruhe judgments go over 100 to 200 pages, amongst which 150 are actually not relevant for the final judgment, but have a lot of interesting reasoning. And in the past, Karlsruhe always gave green light to all the treaties, but it included a lot of criteria why certain things should not happen. So therefore, also ultimately, the judgments of the Constitutional Court sounded more critical than they were as a result. The only one where it now hurt was the PSPP, but here we saw that also here, the German Constitutional Court in the PSPP judgment based its ultra-virus claim not on the fact that the ECB decision was unproportionate or disproportionate, but there was a lack of reasoning on which they could base whether there was any proportionality assessment done or not. And that is rather a low violation that can easily be remedied. The biggest problem with this judgment was less in the field of EMU and ECB, but the collateral damage that it had to be very arrogant towards the European Court of Justice in order to overcome a judgment that confirmed the legality of the ECB, that then might trigger other courts to follow. But in general, it's not only Karlsruhe that has this issue.
Well, you also earned a lot of fans in the chats. There are many thanks and many congrats and so on. And I would claim that most of the questions you actually already answered in your talk. So therefore, I only would like to quote a last thank you. Bravo, thanks and greetings from Karlsruhe, from Yongplum. And now it goes straight to Franziska Brandner to draw some conclusions. Now Berlin speaking.
Yeah, thank you and hello from Berlin. Hello to Rotterdam. I'm pleased to see that you are already adapting the Dutch accent when you speak English, René. It's no longer the Badische one. But let me be serious. I would like to point out one element that you didn't mention, René. The first question, can Karlsruhe actually has it a legal basis on an own resources decision to have the ratification seen as a ratification process? Is this really a ratification of an international treaty? And it's quite interesting when you read the argument that it bases this argument on the title, because the government called it Eigenmittelbeschluss Ratifizierungsgesetz. We could just as well have said Eigenmittelbeschluss Gesetz without the ratification. So, but it's quite interesting when you see what the basis there has been in terms of justification for actually having the right to judge. Second point, you said the identity question, there was a hint in the current now decision that probably the liability in the worst cases would not really, destroy German democracy. I think that was a positive hint in which direction they would probably go. Third point on the ultra-virus, as you said, the distribution of competences, I think that will be interesting, because it has rather quoted, and that brings me to one question that was raised in the chat about expertise. It has rather pointed out to experts and cited expertise that is critical about it. And often I get the question, why can the Bundestag, as one of the, the actors in that case, not suggest expertise? And the thing is that we cannot. It's the judges that call on experts. And even if we find it's a very, biased view in terms of what kind of expertise you accept and call on, we cannot really change it. And I think that is part of something sometimes difficult to understand for other colleagues from other member states in terms of who chooses the expertise and why can't you name any other experts that do also support your claim. And last point, you have mentioned it, is the influence of the Bundestag high enough on the Next Generation EU Fund? I think that was a very interesting question in the Bundestag, because obviously the Bundestag itself has not even taken any decision on the German national plan, the recovery plan. I'm like, the Italian parliament voted it now. The German Bundestag never voted its own national reform plan, but Karlsruhe expects us to check on the other plans and take decisions on them. So in a way, it leads a democracy to a certain extent to absurdity, because we are really responsible for checking the one by our own national government, which we're not doing, which Karlsruhe is not claiming. And then we had a resolution by a proposal by the Liberal, the FDP party, suggesting that the committee on budget alone, not the parliament, but the budget committee could take a vote on each national member state's reform plans, which I think was quite absurd to believe that it could be just one committee taking such broad decision while never deciding on our own national plan. So much to see still in the implementation, in the discussion in Germany. We will see who will be the successors of Huber. That will be interesting. There are 5 members of the House to be replaced in the next legislative term. It will be important decisions. And I think we will all push for an ambitious European fiscal policy. And thank you everyone for having joined us today in this debate. It's always a pleasure to do this, Brussels, Berlin, Rotterdam, to have you join us today. It will remain an interesting debate, but I'm happy that we can go forward with the Next Generation EU Fund now. And I wish that all member states were as ambitious as some of the other member states are. Thank you all.
Vielen Dank und bedankt. And for all the German speakers on Saturday, we will have on the Day of Labor a large seminar with Annalena Baerbock and with Julia Friedrichs, a top-selling author, investigating the conditions of the working class in Germany, in particular at the lower end of the social spectrum. And we are looking forward to that discussion. I wish you well. Greetings to Rotterdam, greetings to Berlin. See you again. Thank you, René. This was just excellent. Bye-bye and all the best. See you again.
Bye. Tschüss. Alle zusammen.